All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Would the court officer, once we have the pictures being taken, thank you very much. Would the court officer please call the case? Thank you.
Yes, Mr. President, good afternoon. Situation in the Democratic Republic of the Congo. In the case of the prosecutor versus Thomas Lubanga Dyilo, case reference ICC 0104-0106, and for the record, we are in open session.
Thank you very much. May I ask the parties to introduce themselves for the record, starting with the Office of the Prosecutor.
Thank you, Mr. President. Mr. President, honorable judges, the Office of the Prosecutor is represented today by Mr. Fabrizio Wariglia, Director of Prosecutions, Nicole Sampson, Senior Trial Lawyer, Manoj Sachdeva, Trial Lawyer, Carmen Garcia Ramos, Case Manager, and myself, Fatou Bensouda, Prosecutor.
Thank you very much. And moving to the other side, the defense of Mr. Lubanga.
Merci, Monsieur le Président. La défense est représentée par Caroline Buteau, Jean-Marie Bijoux-Duval et Catherine Mabilly, moi-même.
Merci. And then to the legal representatives for victims, I understand that you'll be representing both groups today.
Merci, Monsieur le Président. Mon nom est Luc Wallin. Je représente en effet ma propre équipe V01 ainsi que par procuration l'équipe V02. Je suis assisté par les deux case managers des deux équipes, Madame Evelyne Ombeni et Madame Sylviana Gogino.
Merci. Thank you so much. And introducing ourselves, to my right, there is Judge Song, and then Judge Monaheng, and to my direct left, Judge Ushacka, and the next is Judge Trendafilova. My name is Erkki Kourula, and I am the presiding judge of this appeal. Today, the Appeals Chamber is delivering its judgment on the appeal by Mr. Lubanga against the decision of Trial Chamber I, entitled Judgment Pursuant to Article 74 of the statute, as well as its judgment on the appeals of the prosecutor and Mr. Lubanga against the decision of Trial Chamber I, entitled Decision on Sentence Pursuant to Article 76 of the statute. In today's summary, if I may, I will refer to these two impugned decisions as the conviction decision and the sentencing decision, respectively. I will refer to Monsieur Thomas Lubanga Dyilo as Mr. Lubanga, and I will first summarize the Appeals Chamber's judgment on Mr. Lubanga's appeal against the conviction decision. Please note that only the written judgment is authoritative. It will be notified to the parties shortly after this hearing. On the 14th of March 2012, Trial Chamber I delivered a conviction decision convicting Mr. Lubanga pursuant to Articles 8, para 2, E Roman 7, and Article 25, 3A, paragraph 3A of the statute of having committed jointly with others the following crimes: conscripting and enlisting children under the age of 15 years into the UPC, FPLC, and using them to participate actively in hostilities in Ituri, the Democratic Republic of the Congo, between early September 2002 and the 13th of August 2003, in the context of a non-international armed conflict. On the 3rd of October 2012, Mr. Lubanga filed his notice of appeal. And on the 3rd December 2012, Mr. Lubanga filed his document in support of the appeal against the conviction decision. On the 4th of February, then, the following year, the prosecutor filed her response to the document in support of the appeal. Victims groups 1 and 2 participated in the proceedings by way of written and oral observations. Mr. Lubanga raises numerous arguments under 3 overarching headings that are further divided into 7 separate subcategories. The Appeals Chamber has addressed Mr. Lubanga's arguments according to these subcategories as 7 grounds of appeal. In addition to these grounds, and I'll deal with them first, of appeal raised in Mr. Lubanga's document in support, he also filed 3 additional evidence requests. On the 26th of November 2012, Mr. Lubanga filed a request to present additional evidence in his appeals against the conviction decision and the sentencing decision. The first additional evidence request included a request that the Appeals Chamber hear the testimony of 2 witnesses whom I will refer to as witnesses D40 and D41. On the 23rd of December 2013, Mr. Lubanga filed a second request to present additional evidence in his appeals against the conviction decision and the sentencing decision. In his second additional evidence, Mr. Lubanga also sought leave to add a new ground of appeal, which was granted by the Appeals Chamber on the 14th of January 2014. The 19th and 20th of May this year, the Appeals Chamber held an oral hearing at which it heard the testimony of witnesses D40 and D41, as well as further submissions of the parties and participants on the issues arising in the appeal. On the 23rd of May this year, Mr. Lubanga filed his third additional evidence request seeking the admission of documents referred to during the testimony of witnesses D40 and D41. As this is the preliminary issue, the Appeals Chamber will first address, as I explained, the admissibility of the additional evidence contained in Mr. Lubanga's 3 requests. The criteria applicable to the admissibility of additional evidence on appeal are provided in the court's legal texts and derive from the nature and purpose of appellant proceedings, which are corrective in nature. In addition, the trial chamber is better positioned than the appeals chamber to assess a piece of evidence in light of all the other evidence presented at trial. Accordingly, evidence should, with only limited exceptions, be presented at trial. With these considerations in mind, the Appeals Chamber finds that the additional evidence on appeal is admissible if A. The Appeals Chamber is convinced of the reasons why such evidence was not presented at trial, including whether it could have been presented with the exercise of due diligence. And B. It is demonstrated that the additional evidence, had it been presented before the trial chamber, could have led the trial chamber to enter a different verdict in whole or in part. Furthermore, the Appeals Chamber considers that additional evidence may be admitted on appeal for purposes of demonstrating that the proceedings appealed from were unfair and thereby rendered the decision pursuant to Article 74 unreliable. In applying these criteria to Mr. Lubanga's 3 additional evidence requests, the Appeals Chamber finds that all of the proposed additional evidence is inadmissible because it was either available at trial, would have been available with the exercise of due diligence, or is inadmissible because the Appeals Chamber does not find that the additional evidence, had it been presented during the trial, could have led the trial chamber to enter a different verdict in whole or in part. Regarding witnesses D40 and D41, specifically, the Appeals Chamber finds that Mr. Lubanga could have presented this evidence at trial and is therefore not persuaded by his arguments as to why he failed to do so. I shall now turn to Mr. Lubanga's first ground of appeal, which relates to whether the charges for which he was convicted were sufficiently detailed. Mr. Lubanga submits that the charges for which he was convicted were insufficiently detailed with respect to the dates and places pertaining to the instances of enlistment, conscription, or participation in hostilities, as well as with respect to the identity of victims. He argues that because he was not informed in sufficient details of the charges for which he was convicted, his ability to prepare his defense was prejudiced. The Appeals Chamber considers that information relative to the charges in the present case was provided in the document containing the charges and in the decision on the confirmation of charges, as well as in the amended document containing the charges and the summary of evidence. In his submissions, however, Mr. Lubanga only cursorily refers to the decision of the confirmation of charges and does not refer to the amended document containing the charges or the summary of evidence. The Appeals Chamber finds that Mr. Lubanga should have substantiated his submissions by reference to the latter documents. The Appeals Chamber also notes that when alleging prejudice, Mr. Lubanga does not demonstrate that his ability to defend himself was materially impaired by reference to the evidence presented at trial and relied upon in the conviction decision. The Appeals Chamber therefore finds that Mr. Lubanga has failed to substantiate his argument that the charges were insufficiently detailed with respect to the dates and places pertaining to instances of enlistment, conscription or participation in hostilities, and also with respect to the identity of victims. Furthermore, Mr. Lubanga has failed to substantiate the prejudice he suffered because of the allegedly missing details. Accordingly, the Appeals Chamber dismisses this ground of appeal. Under the second ground of appeal, Mr. Lubanga alleges that the trial chamber erred in how it took into account certain purported failings of the prosecutor to comply with statutory obligations, which, in Mr. Lubanga's view, rendered the trial unfair. The Appeals Chamber notes that many of the allegations under this ground were addressed by the Trial Chamber in its decision of the 23rd of February 2011 concerning Mr. Lubanga's request for a permanent stay of proceedings. In that decision, the Trial Chamber found that, taken at their highest, none of the alleged violations rendered the trial unfair and denied the request for a permanent stay of proceedings. On appeal, Mr. Lubanga does not challenge the approach or findings in the stay of proceedings decision. The Appeals Chamber will therefore not address any of his submissions that were decided upon in that decision. Mr. Lubanga argues that the prosecutor violated her statutory duties to first, fully investigate exonerating evidence and ascertain the reliability of or verify incriminating evidence. Second, disclose exculpatory evidence and evidence affecting the credibility of incriminating evidence. 3, remain independent, and 4, respect Mr. Lubanga's right to fairness and impartiality. The Appeals Chamber dismisses or rejects all of Mr. Lubanga's arguments under this ground of appeal for failing to substantiate his arguments, misrepresenting the trial chamber's holdings and the trial record, and because the Appeals Chamber finds no errors in the steps taken by the trial chamber in order to ensure the fairness of the proceedings. Accordingly, the Appeals Chamber dismisses Mr. Lubanga's second ground of appeal. Under Mr. Lubanga's third ground of appeal, he argues that the trial chamber failed to make any finding on the prosecutor's presentation of false evidence and the impact that this had on the integrity of proceedings. He submits that the exceptional gravity of such a situation amounts to an abuse of process. The Appeals Chamber observes that under this ground of appeal, Mr. Lubanga in essence raises the same arguments as those in the preceding ground of appeal. To the extent that the arguments are repetitive, the Appeals Chamber will not address them again. Mr. Lubanga also appears to argue that the prosecutor purposefully presented false evidence to the trial chamber and that the trial chamber should have acquitted him because the prosecutor's conduct damaged the integrity of the trial. The Appeals Chamber considers that Mr. Lubanga has not substantiated his arguments and that these arguments appear to be based solely on misleading and incorrect assertions by Mr. Lubanga regarding the trial chamber's findings and statements. They are therefore dismissed in limine. Accordingly, the Appeals Chamber dismisses Mr. Lubanga's third ground of appeal. Under the fourth ground of appeal, Mr. Lubanga argues that the trial chamber made legal and factual errors by relying for the purpose of establishing the age element of the crimes on its own assessments of video excerpts and on non-expert witness testimony. The Appeals Chamber rejects all of Mr. Lubanga's legal arguments under this ground of appeal. With respect to the Trial Chamber's overall approach to establishing the age element based on its own assessment of video excerpts depicting individuals allegedly under the age of 15 years, the Appeals Chamber considers that the question of whether such evidence can establish the element of age is a question of fact. The Appeals Chamber considers that one factor relevant to its review of whether a trial chamber's factual finding was reasonable is whether the trial chamber appropriately exercised caution when assessing the age of an individual on the basis of video images. Based on the trial chamber's cautious approach on the video excerpts, the Appeals Chamber does not find that this overall approach was unreasonable. Mr. Lubanga also challenges the trial chamber's reliance on non-expert witnesses' assessment of individuals based on their physical appearance to establish the age of those individuals. The Appeals Chamber considers that the trial chamber exercised caution in assessing the evidence of non-expert witnesses. It also carefully evaluated each witness's capability to assess age and took into account factors such as their experience in dealing with demobilized children, their knowledge of the conditions in the area, and the level of contact that they had with the individuals whose age they were assessing. Accordingly, the Appeals Chamber finds that the trial chamber's reliance on this evidence was not unreasonable. Mr. Lubanga also challenges the trial chamber's assessment of specific video excerpts and the reasonableness of its reliance in the specific witnesses who assessed the age of individuals based on their physical appearance, as well as a piece of documentary evidence. The Appeals Chamber dismisses or rejects all of these arguments for reasons further explained in the judgment on the appeal. Under the fifth ground of appeal, Mr. Lubanga challenges his conviction for having conscripted individuals under the age of 15 years into the UPS FPLC. First, Mr. Lubanga argues that the trial chamber relied solely on evidence regarding recruitment and mobilization campaigns and evidence demonstrating only the presence of individuals below the age of 15 years within the UPC FPLC. Mr. Lubanga argues that this evidence does not contain the element of compulsion which is required for the crime of conscription. The Appeals Chamber finds that the recruitment campaigns contained instances of conscription by way of force or threat of force. Mr. Lubanga did not challenge these instances. Therefore, the Appeals Chamber does not need to consider Mr. Lubanga's arguments relevant to whether daily living conditions in Ituri at the time or the pressure exerted on communities establish the element of compulsion that distinguishes conscription from enlistment. Second, Mr. Lubanga argues that the distinction between the crime of enlistment and that of conscription is that the act of conscription entails the child's incorporation into the armed group against his or her will. The Appeals Chamber rejects this argument because that the act is against the conscripted individual's will is not a required element of the crime of conscription. Finally, Mr. Lubanga argues that the trial chamber erred in holding that the separate crimes of conscription and enlistment could be dealt with together. The Appeals Chamber considers that although it's problematic that the overall conclusions of the trial chamber do not clearly identify which facts establish the distinguishing element of compulsion, the trial chamber's decision to deal with these two crimes together does not amount to a legal error, because the trial chamber's findings relevant to the element of compulsion were discernible and reviewable for both Mr. Lubanga and the Appeals Chamber. Moving to ground 6, Mr. Lubanga raises legal and factual errors in relation to the trial chamber's finding that he was guilty of having used jointly with others children under the age of 15 years to participate actively in hostilities. The legal errors turn around the definition applied by the trial chamber in determining what constitutes use to participate actively in hostilities. The Appeals Chamber rejects Mr. Lubanga's alleged error that only direct participation in hostilities, as understood in international humanitarian law, is covered by the phrase to participate actively in hostilities. The purpose of Article 8, Para 2e, Roman 7 of the statute is different from that of the principle of distinction between combatants and civilians in international humanitarian law. However, the Appeals Chamber finds that the trial chamber erred in interpreting which indirect activities of a child would fall within the scope of Article 8, Para 2e, Roman 7 of the statute. It finds that there is no support for establishing as a distinguishing criterion whether a child would, due to his or her activities, be exposed to real danger as a potential target. Rather, it is necessary to analyze the link between the activity for which the child is used and the combat in which the armed force or group of the perpetrator is engaged. Nevertheless, this error is without consequence in the circumstances of the present case, because the trial chamber found that individuals either participated in combat or were guards or bodyguards in a conflict zone. There was therefore a sufficient link to the combat. As to the number of factual errors raised by Mr. Lubanga in relation to the trial chamber's findings that individuals under the age of 15 years were used to participate actively in hostilities, the Appeals Chamber either dismisses the arguments as not substantiated or rejects them because the trial chamber's findings are not unreasonable, or finds that the errors have no material effect for reasons further explained in the judgment. Finally, ground 7, the trial chamber found Mr. Lubanga guilty of having committed the crimes of conscripting or enlisting children under the age of 15 years and of using them to participate actively in hostilities as a co-perpetrator pursuant to Article 25(3) of the statute. The trial chamber found that Mr. Lubanga, together with others, agreed to and participated in a common plan to build an army for the purpose of establishing and maintaining political and military control over Ituri. This resulted in an ordinary course of events in the conscription and enlistment of boys and girls under the age of 15 years, and they used to participate actively in hostilities. Mr. Lubanga alleges legal and several factual errors in the trial chamber's findings of his individual criminal responsibility. First, he alleges that the trial chamber erred in finding that the agreement on a common plan leads to co-perpetration if its implementation embodies a sufficient risk that in the ordinary course of events a crime will be committed. He raises the same argument with respect to the trial chamber's findings on the mental element, in relation to which the trial chamber also referred to the notion of risk. The Appeals Chamber rejects both alleged legal errors. It recalls that these findings are based on the trial chamber's interpretation of Article 30 of the statute, and in particular on the phrase, I quote, "will occur in the ordinary course of events," unquote. According to the Appeals Chamber, this means that it must be virtually certain that in the ordinary course of events a consequence will occur. The Appeals Chamber considers that the trial chamber's reference to the notion of risk is confusing and should have been avoided when interpreting Article 30, Para 2 of the statute. Nevertheless, the Appeals Chamber does not consider that the trial chamber's approach broadened the scope of Article 30 of the statute. In its legal conclusions, the trial chamber emphasized that the consequence will occur in the ordinary course of events. The trial chamber therefore adhered to the terms of Article 30 of the statute, and it also found that in the specific circumstances of Ituri at that time, the common plan of building an effective army in order to ensure the UPC FPLC's political and military control over Ituri directly led to the recruitment of individuals below the age of 15 years. Therefore, the common plan included non-criminal calls in addition to criminal ones. Accordingly, the trial chamber's requirement of a critical element of criminality of the common plan means, in the context of the present case and the specific allegations against Mr. Lubanga, that it was virtually certain that the implementation of the common plan led to the commission of the crimes at issue. Secondly, Mr. Lubanga argues that the trial chamber erred in finding that the co-perpetrator does not need to personally and directly participate in the commission of the crime. The Appeals Chamber rejects this alleged error. The trial chamber found, based on the control of the crime theory, that the co-perpetrator must make an essential contribution and does not need to personally and directly commit the crime. The Appeals Chamber confirms this approach of the trial chamber on the basis of its interpretation of Article 25, Para 3 of the statute. It considers that in circumstances where the plurality of persons was involved in the commission of crimes under the statute, the question of whether an accused committed a crime can't only be answered by reference to whether he or she directly carried out the incriminating conduct. What is required is a normative assessment of the role of the accused person in the specific circumstances of the case. The most appropriate tool for conducting such an assessment is an evaluation of whether the accused had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission, even if that essential contribution was not made at the execution stage of the crime. Accordingly, the Appeals Chamber is not convinced by Mr. Lubanga's argument. Mr. Lubanga also seeks to challenge the Trial Chamber's factual findings in applying the established legal standard. The Appeals Chamber finds some of the arguments as unsubstantiated and rejects the remaining errors, finding that the Trial Chamber's assessment of the facts was not unreasonable. Thus, the Appeals Chamber, by majority, Judge Song partly dissenting, Judge Uszczacka dissenting, confirms the conviction decision and rejects the appeal. Judge Song and Judge Uszczacka will now briefly summarize their opinions. I give you the floor first, Judge Song.
Thank you, Mr. Presiding Judge. I agree with the majority of the Appeals Chamber that it is appropriate to reject Mr. Lubanga's appeal. However, I respectfully disagree with the majority's determination that it is not necessary to decide the legal issue of whether Article 8, Paragraph 2E, Roman numeral 7 of the statute contains 3 separate offenses or 3 separate conducts by which the same offense can be committed. In my view, Article 8, Paragraph 2E, Roman numeral 7 of the statute contains 3 separate conducts of one and the same offense. This conclusion is supported by the examination of the provision's ordinary meaning, together with the elements of crimes, and is further supported by the object and purpose of the underlying international humanitarian law provisions. The relevant drafting history of the Rome Statute, as well as the jurisprudence of the Special Court for Sierra Leone. Therefore, Mr. Lubanga should have been convicted of having committed one crime. Entering a conviction for one crime instead of for 3 crimes is of sufficient importance for the Appeals Chamber to have proprium motu address this issue. This concludes the summary of my opinion on the conviction decision. Thank you.
Thank you, Judge Song. I'll give the floor to Judge Uszczacka.
Thank you, Presiding Judge. I respectfully disagree with the decision of my colleagues to confirm the conviction decision, which I would have reversed, firstly, on the grounds that the charges of which Mr. Lubanga was ultimately convicted were not sufficiently detailed, and secondly, because it was not established beyond reasonable doubt that children in the UPC, FPLC were under the age of 15. Regarding the charges, I consider that 9 individual cases constituted the material facts underlining the crimes charge, which the prosecutor had to establish through the evidence at trial. The remainder of allegations regarding a pattern of crime did not contain reference to a single identified victim, while the dates and locations were framed in unacceptably broad terms. These unspecific factual allegations could not have been considered to be operational without the 9 child soldiers that constituted the vertebral column of the case. For 5.5 years, the trial proceeded on the basis that the 9 individual cases were the material facts underlining the charges. It was these charges that Mr. Lubanga defended himself against, yet he was ultimately convinced of the unspecific charges of a pattern crime. The right to be informed of the charges is a necessary precondition of fair trial, and fairness can never be achieved if the accused is deprived of this right. In this case, the abstract nature of the remaining charges allowed vague assertions that children were enlisted or conscripted in the UPC, FPLC, or used in hostilities to be presented as evidence. The lack of concrete information in the evidence presented meant that Mr. Lubanga was deprived of a meaningful opportunity to challenge the evidence at trial. Ultimately, even the factual conclusions of the trial chamber suffered from the same level of imprecision. In my view, the evidence relied upon by trial chamber to convict Lubanga was not sufficient to reach the threshold of beyond of reasonable doubt. Although the trial chamber noted the applicable standard in one line of conviction decision, it appeared thereafter to have in practice applied a lower standard. In my view, this raises concerns that the trial chamber was motivated more by the desire to create a record of events rather than to determine the guilt of individual to the standard applicable in criminal proceedings. I consider that the evidence in this case was in particular not sufficient to establish that at least some of children in the UPC, FPLC were under the age of 15. Estimating the age of individual based solely on his or her physical appearance is very complex and prone to error, even when scientific methods are used. For these reasons, the trial chamber indicated that in adopting a cautious approach when assessing the evidence in relating to age determination. For its purposes, it relied exclusively, first, age estimates given by lay witnesses, second, its own estimate of the age of individuals appearing in videos. And third, an internal UPC FPLC letter dated 12 February 2003, referring to the demobilization of children between the ages of 10 and 15 or 16. As regards to the witnesses, the trial chamber relied on late witnesses' estimates of the age of unknown and unidentified individuals. Often the witnesses did not offer any explanation of how they knew that the child in question was under 15, and frequently the witnesses referred to children that were relatively close to the age of 15. The trial chamber also relied extensively on the testimony of witness P46, who worked in the Manuk demobilization program and whose knowledge of the children she encountered was entirely based on what the children themselves had told her. In my view, the trial chamber's unquestioning acceptance of this evidence did not display the requisite degree of caution. Regarding the video evidence, the trial chamber stated that it only relied on video excerpts that depicted children who were manifestly under the age of 15. Yet the children appearing in video excerpts rely upon by trial chamber appeal, in my view, to be close to age of 15 to allow a determination beyond reasonable doubt that they were below that age. They are frequently only partly visible, and their sizes are unclear in the absence of any objective comparator. The trial chamber disregarded these problems and simply found that the images spoke for themselves. The video excerpt of the boy playing with insect is, in my view, by far the strongest in terms of quality of the lighting, the clarity of the image, and the close range of relevant individual. Yet the person depicted was located by Mr. Lubanga defense team and called to give evidence before the appeal chamber as witness D40. In his testimony, witness D40 stated that he was aged between 19 and 20 years at the time that the video was filmed. Mr. Lubanga also called another individual who appeared on one of the video excerpts relied upon by trial chamber. This individual was witness D41, who testified that he was between the age of 17 and 18 at the time that the video was filmed. I disagree with the decision of majority of appeal chamber not to admit this additional evidence. In my view, in light of the overall weakness of the evidence establishing that some children were under the age of 15, the submitted additional evidence in relation to witnesses D40 and D41 clearly has the potential to demonstrate that the approach of the trial chamber was flawed and thereby have an impact on conviction. Finally, I disagree with the trial chamber's conclusion that the letter of 12th of February 2003 corroborates other evidence that the children under 15 were part of the UPC FPLC at that time. The letter refers only to the training of officers on demobilization and not to the presence of children in the UPC FPLC. The letter has a much wider scope than the UPC FPLC, given that the process referred to in the letter deals with child soldiers as concerned in the entire region. Accordingly, I do not consider that this item of documentary evidence assists in establishing the age element of crimes. Therefore, I consider that the requisite element of crimes has not been established beyond reasonable doubt. It is my hope that future prosecutions of these crimes at the court will adduce direct and more convincing evidence and preserve the fairness of proceedings. Fairness lies in the heart of criminal proceedings, and the fundamental rights of accused should not be sacrificed in favor of putting historical events on the record. In view of this consideration, I would have found that it was not reasonable for trial chamber to convict Mr. Lubanga of the crimes conscripting and enlisting children under the age 15 years into UPC, FPLC, and of using them to participate actively in hostilities from 1st September 2002 to 13 August 2003 within the meaning of Article 8, Paragraph 2E, Roman 7, and Article 25, Paragraph 3A of the statute. I therefore also disagree with the conclusions of the majority with respect to sentencing.
Thank you, Judge Ušacka. I will now turn to the summary of the judgment on the sentencing decision. On the 10th of July 2012, having received written submissions from the parties and participants, and having heard them as well as evidence related to sentencing, the trial chamber sentenced Mr. Lubanga first for conscripting children under the age of 15 to 13 years of imprisonment, secondly for enlisting children under the age of 15 to 12 years of imprisonment, and for using children under the age of 15 to participate actively in hostilities to 14 years of imprisonment. On the basis of these individual sentences and pursuant to Article 78, Para 3 of the statute, the trial chamber imposed a joint sentence of 14 years of imprisonment. On the 3rd of October 2012, the prosecutor and Mr. Lubanga filed their respective notices of appeal, and on 3rd September 2000, the same year, they filed their respective documents in support of their appeals against the sentencing decision. Starting with the standard of proof and the standard of review, the Appeals Chamber considers that Article 78 of the statute and Rule 145, Para 1 of the Rules of Procedure and Evidence indicate that in order to determine a sentence, the trial chamber, based on its intimate knowledge of the case, will have to balance all factors it considers relevant. Therefore, the trial chamber's determination involves an exercise of discretion with the aim to impose a proportionate sentence that reflects the culpability of the convicted person. Nevertheless, the Appeals Chamber stipulates that Rule 145, Para 1C of the Rules of Procedure and Evidence requires, in addition to the factors mentioned in Article 78, para 1 of the statute, that the trial chamber give consideration to a non-exhaustive list of additional factors contained in this legal provision. As to the standard of review, the Appeals Chamber's primary task is to review whether the trial chamber made any errors in sentencing the convicted person. The Appeals Chamber's role is not to determine on its own which sentence is appropriate unless, as stipulated in Articles 83, para 3 of the statute, it has found that the sentence imposed by the trial chamber is disproportionate to the crime. Only then can the Appeals Chamber amend the sentence and enter a new appropriate sentence. The Appeals Chamber determines that its review of a trial chamber's exercise of its discretion in determining the sentence must be deferential. It will only intervene first, if the trial chamber's exercise of discretion is based on an erroneous interpretation of the law. Secondly, the discretion was exercised based on an incorrect conclusion of fact. And thirdly, as a result of the trial chamber's weighing and balancing of the relevant factors, the imposed sentence is so unreasonable as to constitute an abuse of discretion. Furthermore, the Appeals Chamber considers that the material effect of any such an error is only established if the trial chamber's exercise of discretion led to a disproportionate sentence. Turning first to the appeal of the prosecutor. The prosecutor raises 3 grounds of appeal and requests the Appeals Chamber to increase the sentence. First, she alleges that the sentence is manifestly disproportionate due to the trial chamber's failure to adequately consider all the relevant factors and impose a sentence that was commensurate to the gravity of the crimes for which Mr. Lubanga was convicted. Having reviewed the evidence to which the prosecutor points, as well as the sentence imposed on Mr. Lubanga, the Appeals Chamber finds that the trial chamber's exercise of its discretion was not unreasonable. It properly weighed and balanced all the relevant factors in imposing a sentence that reflects Mr. Lubanga's culpability as required by Rule 141, by Rule 145, para 1A of the Rules of Procedure and Evidence. Furthermore, the Appeals Chamber dismisses as unsubstantiated the prosecutor's argument that the sentence imposed was disproportionate to sentences imposed by other international tribunals. Second, the prosecutor alleges that the trial chamber failed to consider Mr. Lubanga's abuse of authority and trust as an aggravating factor. The Appeals Chamber notes that the prosecutor had requested the trial chamber to consider Mr. Lubanga's abuse of authority as an aggravating factor. The trial chamber was therefore cognizant of this request, but decided to take Mr. Lubanga's position as President and Commander-in-Chief of the UPC into account to establish the degree of his participation in the crimes for which he was convicted. The Appeals Chamber can find no error in the trial chamber's approach. Thirdly, the prosecutor raises an error of law in applying the wrong test for aggravating factors, or anti-alternative error of fact in reaching unreasonable findings based on the evidence. The Appeals Chamber finds that the prosecutor mischaracterizes the prosecutor's test and dismisses this argument. And as to the factual errors alleged by the prosecutor with regard to the assessment of facts supporting cruel treatment of and sexual violence, the Appeals Chamber finds that it was not unreasonable for the trial chamber to conclude that the link between Mr. Lubanga and the alleged aggravating factors in the context of the charges has not been established beyond reasonable doubt. Moving to the appeal of Mr. Lubanga, he raises 4 grounds of appeal and requests that the Appeals Chamber set aside the sentencing decision and or in the alternative reduce the sentence imposed by the trial chamber. First, he raises errors of law and fact by the trial chamber in its assessment of the large-scale and widespread nature of the crimes for which he was convicted in relation to the gravity of the crimes. Mr. Lubanga alleges that the trial chamber, in relying on the widespread character of the crimes, also included non-criminal acts, namely the recruitment of individuals of and over the age of 15 years. The Appeals Chamber rejects this argument and finds that the trial chamber relied on findings in the conviction decision that establish the widespread character of the crimes by reference to individuals under the age of 15 years. With respect to the alleged factual errors, the Appeals Chamber decides not to readdress errors already decided upon in the judgment against the conviction decision. Second, Mr. Lubanga raises errors of law and fact, arguing that the trial chamber did not take into account violations of Mr. Lubanga's fundamental rights in determining the sentence. The Appeals Chamber notes that neither the Appeals Chamber in the judgment against the conviction decision nor the trial chamber in the stay of proceedings decision or conviction decision found that a serious violation of Mr. Lubanga's fundamental rights had occurred, justifying a reduction of sentence. In the Appeals Chamber's view, the trial chamber addressed these allegations during the trial proceedings. Furthermore, the Appeals Chamber finds that Mr. Lubanga mischaracterizes the trial chamber's decision in that it didn't find that the stay of proceedings decision affected his right to have the sentence reduced as a form of remedy. Finally, as to the alleged factual errors, the Appeals Chamber finds that Mr. Lubanga does not substantiate how the trial chamber's consideration of Mr. Lubanga's cooperation in light of the prosecutor's actions during the trial as a mitigating factor was unreasonable. The Appeals Chamber dismisses as not substantiated the alleged third ground of appeal that the trial chamber failed to deduct the period of Mr. Lubanga spent in detention in the DRC from 13th of August 2003 until 16th March 2006. Finally, the Appeals Chamber dismisses Mr. Lubanga's fourth alleged error in the trial chamber's finding that it could consider evidence that exceeded the facts and circumstances set out in the decision on the confirmation of charges for purposes of sentencing. The Appeals Chamber finds that Mr. Lubanga did not properly raise this ground of appeal. Thus, in considering that none of the alleged grounds of appeal was successful, the Appeals Chamber by majority, Judge Song partly dissenting, Judge Ušacka dissenting, confirms the sentencing decision and rejects the appeals. As I stated, Judge Ušacka disagrees for the reasons expressed in her dissent to the judgment on the conviction decision as summarized just a while ago. And Judge Song shall now briefly summarize his opinion. Judge Song.
Thank you, Mr. Presiding Judge. In light of my view that the trial chamber erred in holding that Article 8, paragraph 2e, Roman numeral 7 of the statute contains the three separate offenses of conscription, enlistment, and use to actively participate in hostilities, as well as in convicting Mr. Lubanga of these three separate offenses. I find that the trial chamber also erred in entering three separate sentences. Instead, it should have entered one sentence. While I otherwise agree with the reasoning of the majority, I disagree with one single point in the majority's reasoning, that is that it is not necessary in the context of the present appeal to determine which of the possible approaches to the interaction between the factors of Article 78, paragraph 1 of the statute and those of Rule 145, paragraph 1c of the Rules of Procedure and Evidence is correct. In my view, to ensure a consistent sentencing practice, the Appeals Chamber should have provided further guidance on how a trial chamber should take these factors into account when determining sentence. These factors are set out in my opinion. Thank you, Mr. Presiding Judge.
Thank you. Thank you, Judge Song. This concludes the summary of the judgments. It only remains for me to thank the parties and participants, the interpreters and the court reporters. I also would like to thank the registry staff for having facilitated this hearing. Thank you all. This session is now closed.
All rise, vous vous levez.